Okay, right, I will get going. So thank you very much, everybody, for joining this Lunch and Learn. We are just coming up to next month will be our 1-year anniversary of running these events. And they've grown consistently every month. So thank you very much to everybody that has supported us all the way through, and a huge welcome to everybody that is new to these. We've got quite a few new faces booked onto this one, so you're all very welcome. All of our previous Lunch and Learns are available on our YouTube channel and also on our news area of our website. And you can link to those through the email that we'll send out to you after the event. So you can back if there's any particular items that or subjects that we've covered that you'd find interesting. So welcome. Without further ado, it's a massive pleasure today to get Elspeth Grant on as our expert contributor to this Lunch and Learn. When I knew that I wanted to cover the RPEEP subject, I thought there was one name that sprung to mind, and that was Elspeth, in terms of hopefully having mastery over this subject. So Elspeth, do you want to give us a very quick introduction to yourself?
Thank you, Matt. Yeah, I've been involved in delivering strategies and individual PEEPs for evacuation disabled people since 2009. Working with major housing providers, but also working with the government. I also currently sit on the BSR advisory steering group for my sins. Passionate about, as I'm sure you are all, resident safety, but also about keeping responsible people safe too.
Fantastic, thank you. And also, just to introduce myself for anybody that doesn't know, so I'm Matt Hodges-Long. I'm the founder and CEO of Building Safety Register and Risks. Between those two software platforms, we manage end-to-end golden thread and safety case management, safety case report production, and have been involved in this whole legislative change post-Grenfell since 2018-19, right the way through Dame Judith Hackett through to the various Grenfell inquiry reports and out of the other side. So a lot of background in the physical implementation and compliance with these regimes. So hopefully that gives the background to the two of us. So the legal position. So what we're talking about today, we talk about RPEEPs. We're talking about the fire safety residential evacuation plans, England regs, which doesn't trip off the tongue. Effectively, they're made underneath the Regulatory Reform Fire Safety Order 2005, which I'm sure you are all fully aware of and know. And the key point is we're talking about specified residential buildings. And effectively, AFB is the same description as a higher risk building for the Building Safety Act. And then for the purposes of these regulations, we then add in the mid-rise tier, which is 11 to 18 meters, and only where that building has a simultaneous evacuation strategy in place. So all HRBs are in regs, and mid-rise buildings with a simultaneous evacuation strategy are within the scope of these regulations. And the Home Office sponsored them, and they commence. The key point everybody needs to keep coming back to is these regulations commence on the 6th of April. So we are approximately 1 month away from go live date. Just a very quick timeline from Grenfell on 2017 of how we've gone about. So in October 2019, the Grenfell inquiry recommendations recommended the residential PEEPs or evacuation plans. There was a consultation in June 2021, government consultation, another consultation about information sharing in May 2022. July 2025, these regulations were laid before Parliament and effectively signed off, and they go live on the 6th of April. So that's the timeline where we're looking at that 9-year journey, getting on for 9-year journey from Grenfell fire to the go live of residential PEEP regulations. We can probably all have a debate at some point about whether 9 years is a realistic time frame for this change, but that's the reality of where we find ourselves today. Also, just wanted to say I am running through very quickly because when we put this presentation together, I realized we could probably do a couple of hours on every single part of it. So I'm trying to get through this content with Q&A. The slides are quite busy with a lot of information on them, and the purpose of that is to maybe glance off a few points on this lunch and learn, but you've got something to read afterwards or question us about after the event. So I didn't want to leave a shortage of information on the page. Just to say, these regulations, the guidance, are also uploaded to our Building Safety Act Resource Centre, which is freely available for anybody on the call. If you just send an email request to help@buildingsafetyregister.co.uk, then we'll invite you to it. And pretty much all of the government guidance, regulations, statutory instruments, legislation related to the Building Safety Act and other regulations like this are available in their source copy, and we keep those up to date, and the system will alert you when there's an update to any of that content. So again, please send through an email or put something in the chat for the team to pick up if you'd like to be invited to that resource centre. So duties for responsible persons. We've split these down into 10 areas, and what I'm going to do is take everybody through those 10 key duties. They're not necessarily laid out like this in the regulations, but effectively, if you interpret the regulations, we end up with 10, between 8 and 10 duties. And the purpose of today is just to run through each of those so everybody sort of understands and can question about those duties for the responsible person. So first one, identifying relevant residents. So again, there's lots of terminology and jargon in the regulations and the guidance that is, some of it is new to the industry. So we have this concept of relevant residents in law now. So they are specified people people that live within a specified building that we talked about before. So 11 with simultaneous evacuation, 18 plus all. And they have some kind of cognitive or physical impairment or condition that effectively makes them, as I think Elspeth has the term of evacuation impaired, an evacuation impairment of some description. And your duty as a responsible person is to take reasonable endeavours to identify those residents in the building. Some of the key things you need to consider are on the screen there, but it is quite complex when you consider this is an ongoing duty. People are moving in and out of the building. You've got to keep records of your attempts to do this, but you need a process for identifying relevant residents. It's not just a passive, if they come and ask me, I do something. You need to make reasonable endeavours to actually identify those people in each of your buildings that you're responsible for. So that's the key thing, reasonable endeavours. We haven't got any clarity yet on how a court would interpret reasonableness in this particular context. Second duty, once you've identified a relevant resident or they've made themselves available to known to you, you need to carry out a person-centred fire risk assessment. So assessing the relevant resident in terms of their ability to evacuate the building and the risks that surround them. And again, thinking there through their individual needs, what impact that has on the fire evacuation of that person and of the building, and what are the general building risks. So this is contextual to the evacuation strategy for the building and understanding what risks apply to that particular individual relevant resident. You only have to do this for relevant residents that accept your offer or request you to do this. You don't have to force this upon people. Throughout this legislation, it talks about explicit consent, and I'm sure Elspeth and I will come back to that because it's quite a hot topic in certain areas. But yeah, so consent. We're not going in and breaking down people's doors and forcing them to do this. We're making the offer reasonably available, and then when that offer is accepted or a request comes in, we're acting upon it. Third duty. Once we've conducted the person-centred fire risk assessment, PCFRA, then there is a duty to implement mitigating measures. Again, if these mitigating measures are agreed and costs can be determined. So again, who pays for this? These measures, if there's a cost associated, are either borne by the responsible person or residents through the service charge, or the individual relevant resident, depending on reasonableness. So again, there's a big debate here potentially to be had about actually who picks up the bill. If between you and the relevant resident you agree that a mitigating measure or measures are required, we're then into a discussion around who pays. And if there is no agreement to pay, then again, there's no requirement to implement. But again, this is a huge area of potential division and confusion when actually this comes to realistic implementation of these regulations. So again, what is the impact of them? Feasibility? What is the degree of risk that you're managing? If there's a general benefit to all residents, then that's something that's more service chargeable, responsible person cost versus something that is purely for the relevant resident. So a difficult area, but the key thing is to sort of have to document that conversation and the debate around mitigating measures and their effectiveness. But throughout, it's all about reasonableness and proportionality. So again, I think having a situation where there is no discussion around mitigating measures, or just a pure sort of throwing it out based on the fact it would be too expensive without having a conversation or asking the resident, would not be reasonable and proportionate. But similarly, doubling everyone's service charge to pay for mitigations in one flat or in the building may not be an appropriate, reasonable, proportionate use of that service charge account. So again, this is all sort of building specific. Fourth duty, we need to agree and record an emergency evacuation statement, an EAS or an EES. Again, reasonable endeavours, but this is looking at what adjustments need to be made, or variations need to be made, or arrangements are in place to actually assist that evacuation impaired resident with their emergency evacuation. So again, that again is a point of agreement with the relevant resident. It all needs to be agreed, it needs to be recorded, and it needs to be informed by the person-centred fire risk assessment. Again, reasonable endeavours all the way through. And at each of these sort of points, there's an opportunity, by our understanding, for the relevant resident to say, do you know what, I want to get out of this process, I don't want to carry on with this. Again, if that's the case, record that information, and there will be a duty to revisit later on, just in case that information or that request is changed. Once the PCFRA is in place, mitigations and the EES or the EAS, you've got to keep this under constant review. So there is a regulatory backstop at 12 months, but a requirement that it could be earlier if conditions change or anything changes. So again, this isn't a one and done, do this 1 year and forget about it for 10 years. This is constant review, in the same way that your requirement to identify relevant residents is continuous, because people move in and out, people get evacuation impairments, they cease to have evacuation impairments. This is not a static environment that we're working with. All the way through resident agreement, you know, this is the key thing. This should always be consensual. This interaction with the residents, and it is a continuous duty. Okay. Number 6, providing information to the fire service. So there are a number of duties, or a couple of duties. One is to make sure that the fire service are informed that you have relevant residents in the building, and the guidance and the regulation talks about the 4 key points there, which is the flat number, the floor number, basic details on the assistance they require, and the existence of an emergency evacuation statement. We'll come on in a bit to what the fire service are doing, but this is a really sort of contentious issue about how much information is given. But the key thing here to remember is that you need explicit consent from that relevant resident or their resident representative. There's another RR, which we'll come on to in a minute. Their legal guardian, effectively, or their LPA attorney, to share that information with the fire service. If they do not provide that explicit consent, as per these regulations, you do not have to provide that information. There is a point which I think Elspeth will come on to later, which is around the Data Use and Access Act, and whether that may overwrite this for emergency purposes, but it's not entirely clear. For the moment, what we're looking for is for people to say, yes, I agree with that emergency evacuation statement, and I also consent to you providing this information to the fire and rescue service to help with my evacuation, to inform them. There is also a requirement later on for sharing the building emergency evacuation plan as well, which isn't in this slide. And how you share can be digital, or it can be analog in your secure information box in the building if you have one, or it can be both. And the fire and rescue service are empowered to determine how they would like to receive that information from you as the responsible person. And we'll come on to that again in more detail in terms of how that's working. So it may well be on paper in your secure information box only. It may well be digital only, but at that point, we would also recommend that you put a copy in your secure information box, or they may not have told you at all. And that is the case with quite a few of the services at the moment. All the way through this, there is a duty to consider data protection. This could be, depending on how you've conducted the PCFRA, what you've done with the East, there could be a lot of very sensitive information that you as a responsible person are collecting about that particular resident. And it is your duty to protect that information in accordance with Data Protection Act and GDPR, etc. So again, just be very careful about what your people are collecting, and then once you have that information, who you're making that information available to, and the method by which you're transmitting it. And again, all of that work that you're doing needs to be recorded, because, as I often say to people, if you can't evidence it, it didn't happen if it comes to some kind of investigation. And always remember that point of explicit consent from the resident. Seventh duty, engaging with the resident's representative. So again, there are two concepts of, or two types of person that can represent a relevant resident other than the relevant resident. The first one is the resident's representative, which is in the regulations, which is somebody with legal power of attorney or guardianship over the relevant resident. So it might be a child, and it might be the parent. It might be somebody that's cognitively impaired and has a lasting power of attorney in place, or a guardian. Somebody with legal standing. They can speak on behalf of the relevant resident to conduct this process. If there is nobody with that, but the relevant resident says, look, I want my son or my brother or my aunt or whoever to help me through this process, or my carer, they are called a trusted person. You can go through this PCFRA process with them, but the guidance says that the relevant resident needs to be effectively in the room or a part of the process with the trusted person. You can't just go off and work with the trusted person in isolation to agree something on someone's behalf. So it's about this sort of legal ability to represent themselves and make agreements. So again, it is quite difficult this when we're starting to look at how a responsible person assesses somebody's capacity, whether the documentation they're being shown is legally valid, etc., etc. There are a number of sort of unintended consequences here. But again, I think if you're doing your best and you're asking those questions, you should be okay. But again, recording that decision. So effectively, I spoke to the resident representative, and then keeping records of the fact that they demonstrated that they were lasting power of attorney of Mrs. Miggins or whatever it is, you should be okay. But understanding who is empowered to be that legal decision maker or have capacity is really important. Again, there are all sorts of safeguarding issues that haven't been spoken about in the regulations. I think individual organisations will work through in terms of their other policies that they should have in terms of how to interact with residents. Complying with data protection regulations. Again, the regulations just effectively say what I've got on the screen there, comply with data protection regulations. And it's when you start thinking, I'm talking about and capturing information about somebody's physical impairment or mental impairment, I know their address. I'm building a data set here at scale, which could be abused or misused by all number of people. Personal opinion, I don't think this has really been thought through properly by whoever wrote the regulations. The guidance isn't clear enough, but effectively that's on you as an organisation to comply with data protection legislation. There are no explicit powers within these regulations to disapply other regulations or statutes. I think Elspeth will come on to talk about this Data Use Act and the sort of provisions there for emergencies and but it is at best unclear as to whether you can effectively take any or all of that decision from the individual resident out of their own hands and share information with the fire service. On the face of these regulations, you absolutely cannot. There is no provision for that. There has to be consent. Again, none of this at the moment has been tested, as far as I'm aware, in any kind of court or any kind of legal opinion about the impacts. There was a point, Elspeth and I have discussed it, but effectively because of the way this legislation or these regulations were made, but effectively by the Secretary of State as a statutory instrument, they bypass a lot of the normal parliamentary process, which would look at impact assessments and other laws, etc. It sort of goes on an accelerated journey through into law. Preparing a BEEP, a Building Emergency Evacuation Plan. This is new terminology to this regulations. We have FEEPs, we have JEEPs, we have evacuation plan, etc. But effectively, what we're looking at here is the emergency evacuation plan, or the instructions to residents that are a requirement within the Fire Safety England regs, with an extra layer of emergency evacuation statement commentary that is then provided to the fire and rescue service or shared with, and it should confirm if there are any relevant residents in the building, other building evacuation arrangements, etc. Again, digital sharing or SIB or both with the fire service, and if you go through this process and effectively you do not have any relevant residents or any explicit consent for emergency evacuation statements within your building, there is still a regulatory duty to provide the building emergency evacuation plan to the fire service. So it's not something that you only do if you have relevant residents. Confirming you don't have any relevant residents is also a part of this requirement and a part of the information sharing duty, which is continuous. So this is the whole building approach. So if you think in the Fire Safety England regs, your emergency evacuation information, the target audience for that is the resident. Effectively, we're doing an enhanced version of that, and the audience is the fire service in terms of how they should respond in the event of a call out to your building. And this applies to all in scope buildings. So again, 11 to 18 meters with simultaneous evac as the strategy, and then everything above 18 meters or 7 stories, regardless of the evacuation strategy. So this is probably 85 to 90,000 buildings at a get. Sorry, no, it wouldn't be. No, sorry, just over 13,000 higher risk buildings, and then however many mid-rise there are that have simultaneous evac. And I think that number is unknown, but there are about 75,000 mid-rise buildings that could fall into that category. So again, maybe if anyone has a number that they can remember that's been bandied around for the number of mid-rise buildings with a simultaneous evac policy, that would be really great for the inner geek in me to be reminded of that number. 10th duty, reviewing the building emergency evacuation plan. Again, maximum 12-month backstop. Earlier if amendments required. Now, if we think there are people adding to the EES, being taken away from EESs as well, because they've moved out, they've died, their impairment has gone because it was transitory or whatever, and then the amendments that may be required to the evacuation strategy of the building to reflect that, then there could well be regular amendments to the Building Emergency Evacuation Plan, the BEEP, in which case that duty kicks in that the fire service need to be updated every time you update that requirement. So this could be a lot of interaction between you and the fire service, and updating your secure information box by running this through the printer and putting the paper back in the box, and making sure you have a process in place to do that. The continuous duty, as I've talked about. So once you've gone through that process, and we'll talk about how to do that in a second, there are two sides to this equation. So there's the responsible person and there's the local fire and rescue authority, or I've called them an FRS here, but in the legislation they're fire and rescue authority. So if we look at the fire service receiving your information first, they are allowed to choose the method by which they want to receive the information from you. If they say this information just needs to go into the secure information box, by our understanding, you have complied with your sharing duty. If they say we need you to fill in this online form and you don't, then it could be argued that you haven't. Or they may say fill in the online form, but also please put it, and we would always say, if they say we want it online, please always put a copy in your secure information box if you have one. At the mid-rise level, it is not mandatory to have a secure information box at the moment unless it's new build. So if it's not new build and it's 11 to 18 meters and it doesn't have one, then if your fire service say, I want it in your secure information box, then legally you have to now go and get one, put it on the wall and put that documentation in the box. Okay, so it does require you to go and do something as a result of these regulations. If it's digital, one of the problems that we found at the moment, and I'll come on to the number in a second, is that currently the fire services that are asking for a digital form completion or digital information upload are asking different questions, and quite often they're asking for more information than is laid down in the regulations. And some of them, if you don't provide answers to those questions, will not let you submit that form. So therefore you are effectively being forced to potentially share information that may well breach data protection regulations, or certainly goes above and beyond what the regulations ask for. So again, this hasn't been resolved yet. I've raised this. I think others have raised it, but there hasn't been a definitive answer yet, or definitive guidance from the National Fire Chiefs or anybody else that we've seen. And again, always think about DPA compliance, because Data Protection Act compliance, because just because the fire service are asking you for this information, to my understanding, does not give you carte blanche to breach data protection law. And each individual fire and rescue service should confirm their sharing method. So, which leads me on, bearing in mind we're a month away from go live. Last week we did an in-depth audit of all of the fire and rescue services in England to actually say, well, where are they? Are they ready? The second column on that spreadsheet that you can see on the screen, which is all red, is quite small text, but effectively are the RPEEP regulations clearly signposted on that fire and rescue service website on their homepage? And the answer 100% is no. The next column across to the right is where we've got green boxes, is where if you dig around in the website, you can find reference to the RPEEP regulations, which was 15 of 43. Got that. And then the next box across is where they start to state a preference. So they've talked about RPEEPs. How do they want the information? So the fourth column across is the ones the Greens say that we want secure information box, please put it in the secure information box. And then the fifth column across is the ones that say digital, the green ones. There are three that say we've got an online form, and then all three of those do not meet the guidance or the regulations. So overall, it's a pretty sort of, to my mind, shocking state of affairs in terms of the lack of clarity around the fire and rescue service side of these regulations. Okay, so that's the fire service bit. Just because they may or may not be ready doesn't absolve the responsible person from their duty to be ready and to implement these regulations effectively. Now, it may well be that you've got all of this information for the fire service and you physically cannot get a copy of it to them, but that doesn't stop you putting it in the secure information box and being able to demonstrate that you've done that. So again, maybe we'll come on to that in a second in terms of interpretation. So from an responsible person's perspective, the RP's perspective, understanding and building this into a process. There are some software platforms to do this. We do this in a workflow way on our Track My Risk Golden Thread platform. There are resident engagement platforms like Itbox that have a more online way of interacting with the resident. However you do it, making sure that you've got a clear process that's followed by everybody. You've got the triggers for the review dates in terms of telling you when you hit your 12-month backstop, that you can evidence your sharing, that is something slightly more than just a random set of events. I would thoroughly recommend, because ultimately what you're shooting for is the evidence of doing something, and most importantly, the defensibility that if the regulator was to say you're not meeting your duties, you can turn around and demonstrate, look at the screen, look at my version control, look at all of these dates, look at this activity. I would assert to you, Mr. or Mrs. Regulator, that I have been absolutely reasonable in discharging my duties under these regulations. And at that point, you've introduced defensibility. Hopefully, you will not be in a situation where there's been an actual incident, people have lost their lives, and you're now looking at this through the lens of a regulatory intervention. Hopefully it would be a proactive visit. But again, your absolute, if you think of this as golden thread, which in my mind it is, this is golden thread information about a particular building. You probably won't have a formal golden thread if you're in that mid-rise category. Although you could argue you should, but that doesn't stop you keeping evidence of your activity. So we're going to go to questions. I'm approximately on time. I think before we do that, Elspeth, you quietly sat there, so thank you very much for sitting through that and me wanting to jump in. Are there any particular points that you wanted to pick up on before we go over to the Q&A?
I think the main point is that primary legislation always takes precedence over secondary legislation. So as far as these regulations are concerned, we are looking at the Fire Safety Order, Equality Act, and also, Matt, you did sort of glance on the whole consent minefield, the Data Use and Access Act. Now, as far as the Fire Safety Order is concerned, very briefly, of course, only applies to common areas of residential buildings, and it specifically excludes domestic premises. So at the moment, the RPEEPs regulations only applies to those areas. Now, what the government has said in their guidance, I think it was para 7.10, is that at some point, as soon as possible, they will be extending RPEEPs into the domestic premises. So that's quite important. The other thing is to remember that the Equality Act specifically prohibits the charging of a disabled person for a reasonable adjustment. And the Equality and Human Rights Commission has already confirmed to disabled people that something like an assisted escape device could be seen as by the courts as a reasonable adjustment. So that's also very important. And as far as the Data Use and Access Act, which came on board rather conveniently in March last year, Schedules 4 and 5 of that Act, in fact, remove the requirement for consent for the case of safeguarding and emergency response. Now, consent is always good to have. good practice, of course it is. But as far as sharing of that information, that Act takes precedence over these regulations. I think those are the three main things, Matt, to remember.
Okay, and I think we've sort of fallen in slightly different areas in terms of that last piece, and but I think what we can agree is that there hasn't been any case law or testing of that interpretation. So I think just for everybody to be, please go out and seek your own legal advice overall.
Absolutely. And I think, Matt, the only other thing is if you're putting information into your premises information boxes, please do not put a list of every single vulnerable and disabled person in your building into that list. And remember that government figures estimate that 24% of residents in any high-rise building are going to be evacuation impaired. So you're actually talking about a lot of disabled and vulnerable people. Code the information, let your fire and rescue services know, because you can see the implications if that list were to get into the wrong hands.
Yeah, and there are actually in the responsible persons toolkit that the government put out, there's actually at least one of the councils that have specifically said we don't put information into our secure information box or PIPs or whatever you want to call them now, because of the fact that they get broken into and they're not secure.
Yeah, absolutely.
So it does beg the question. My thought is that really all of the fire services should be accepting this information digitally and securely, and that should be the primary method of understanding what's going on in any particular given building. And then perhaps you'll have the analog paper as a fallback for failure, but to have your primary method of just saying, yeah, just fling it in a box, seems to be a bit of a cop out. And I'm sure there's probably a counter argument from the fire service in terms of lack of funding, lack of time, whatever, but it does seem to be quite an insecure process at the moment that I would just urge everybody to think it through and do your best and try and do the right thing. And if ultimately the fire service doesn't like it, then at least you can defend yourself. The two wrongs don't make a right, if that's the case. So, Richard, could you chair us on Q&A, please, in terms of anyone that's put their hand up or dropped anything in the chat? Or
yeah, there haven't been any questions coming in on the chat, but I did have a couple sent in earlier. So the first one that I had, what do we do if our FRS has not specified how they wish to receive the information?
Okay, so that kind of picks up on what I was just talking about. So what I would do is make sure that I'm checking their website, I'm formally asking them. So speaking to your primary authority or to your local FRS and the protection people and saying, look, I am a responsible person for X many buildings in your area. I want to comply with these regulations. Please, could you confirm to me as soon as possible how you would like this information? Keep chasing them and recording that conversation. So making sure that you've got that defense, and the fallback is making sure that you've got information to discharge your duties in your secure information box, and you've got evidence that you've done that. So you'll get that through audit evidence, but also just keeping it in the, maybe taking a photo of it and saying, look, here is a contemporaneous photo of me putting the Building Emergency Evacuation Plan in my SIB on this date. Then I opened it again a month later and updated it, and here's a photo, just keeping those records so that you've got some defensibility. I mean, Elspeth, what are your thoughts on that?
Absolutely. Moving forward with scrutiny and all the regulations, it's providing that evidence and records, competency, and making sure that you can actually prove you've done everything that's reasonable. And that's really, really important for both organisations and individuals, remembering that under the fire safety order, it is a personal responsibility for managers to comply, not just an organisational one.
Yeah. Okay, Richard, next one.
Yes, Doug's got his hand up at the moment. Doug, if you want to unmute yourself, you You should be able to. Caroline, have you allowed people to unmute themselves? Oh, you have just. Thank you. Go ahead, Doug.
Cool.
You are unmuted now, Doug. You should be able to speak.
Can you hear me?
Yes, we can.
No, brilliant. Yeah, thank you both very much for the presentation. My question sort of really comes back to the Equality Act, I suppose. If we're looking at PEEPs and we're putting them in place for those with impairments, we surely have to consider their impact on other people. So say if we're using a mobility aid device to move someone down through a stairs, the impact on older buildings which weren't designed to have wide enough stairs for other people to pass down beside them, and so forth. So where's the balance and where's the impact of this?
Do you want to take that one, Elspeth?
Yes, certainly. Hi, Doug. There are a wide range of very sophisticated assisted escape devices now for different physical environments in difficult and for different impairments. So one size does not fit all. Now, if you look at the sort of size of stairwell for Grenfell Tower, for instance, it was only slightly below building regs requirements for today. And under tests, we've tested, and in fact on our website at 3asolutions.tech, there is a video of an assisted escape device being used on that sort of width of stairwell, which still allows people to pass through. And often in a strategy, we will suggest that you can also have a fast and a slow lane. So you can have people moving down one side of the stairwell that are slower than the others. And just remember that Article 15 of the Fire Safety Order, safety drills are, test drills and safety drills are a mandatory requirement of that legislation. In my experience, very rarely done in residential, but there's no exclusion under the law.
No, I appreciate that, Elspeth. We're finding a number of buildings which have stair widths of around sort of 800 mil wide.
Okay.
And this was kind of our area of concern when we had a bit of discussion within our team yesterday.
I can understand that, but certainly if you are using a tracked assisted escape device, they should travel down the stairwell at the same speed as anyone walking.
Brilliant.
So they shouldn't actually hold anyone up. And the most important thing for me is to use a supplier with a wide range of devices, and that they are willing, they come out and demonstrate it in situ. So you can see these devices used on your stairwell. And make sure that the chair is suitable for the impairment of the person, and also that the chair is, I try and get away from the word chair, the device is suitable for the person operating it, because we all see, mentioning no brand names, the canvas type sort of skid chair. But of course, buried in, after you've bought one, buried in the instructions, it kindly states that the operator must be heavier than the occupant.
Can we, Elspeth, can we just quickly, I think, bring in Ed Galea, Professor Ed Galea on this, who's literally written the book on emergency evacuation. I'm hoping he's got his hand up to add to this particular conversation. Ed, if you can unmute.
Hi, Matt, can you hear me?
Sure, go.
Hi, Elspeth.
Hi, Ed.
Really good to see both of you. Just a couple of points about this. One of the issues with evacuation devices is not simply getting down the stairs, is can it make the corner on the landing?
Yeah.
And what we found as part of our work on Grenfell, that a standard evacuation chair could not do, while it could easily go down the stair, it couldn't make the turn. The turn was too tight on the landing. But there were evacuation chairs that were smaller in size, that could make the turn. So again, it's not one size fits all, and literally the size of the chair will be quite important in determining whether you can make that turn, which is going to be critical, probably more critical than the width of the stairs. So that's one issue. The second issue is, in all of our experimental work where we had evacuation chairs, and I'm talking about chairs here, going downstairs, in the hands of a proficient user, the chair was actually faster than the other people going down the stairs. So the chair won't necessarily be a blockage to the flow of people on the stairs if you have a proficient user, and that's really critical. And the third point I want to make is about that, the proficiency of the user, the operator of the chair. They need to be trained, and the training is not necessarily what concerns me is that most of the training, in fact all of the training I've seen, only concerns the usage of the device. It doesn't take into account the strategy for the evacuation. So for example, if the device is in the hands of the operator is slower than the other people going down the stairs, and there are people queuing up behind them, they should consider parking either on the landing if there's sufficient space, or perhaps moving on to a safe floor to allow the crowd to pass. There are issues there that need to be considered and part of the evacuation strategy. Simply going down the stair, and if you're causing a blockage, blocking everybody behind you, is not necessarily the best option, but it needs to be considered as part of the strategy. And this needs to be part of the training of the operator.
Can I just pick up on a couple of very quickly? I agree with you, Ed, certainly with the turn, the different devices. I probably start to get a little nervous about holding back disabled people to let the non-disabled people through simply because of the Equality Act and discrimination. That you might do that in practice, and that might be a decision a disabled person and their operator makes, but to write that in a strategy, I suspect, could cause problems in the future.
Well, I mean, yes.
Just a note about that.
I mean, but then the question is, are you discriminating against the other people?
Well, I think you're giving everyone the same, as long as you're giving everyone the same chance. An option.
I think we need to move this one along now, because as I said earlier, we could spend hours on each of these individual points, and I'm sure people have. But I think it demonstrates the complexity of what we're dealing with here, and this isn't an overnight decision of how to do this. Kida or Kader, you've got your hand up. Do you want to unmute and ask us a question?
After this one, Matt, if we can jump into some of the questions in the chat channel as well.
Yeah.
Sorry, I've covered both bases because I put it in the chat as well. So apologies if it has already been covered. Most large organisations are going to use any kind of data collection exercise to enhance what they already have. So whilst we are going to prioritise vulnerabilities that have already been identified, and taking into account that it is person-centred and consent is needed for that person, what level of referral can we accept from the person in front of us regarding other household members? So, for example, somebody, we knock on the door, they answer, there are 0 risks identified, a PCFRA is considered, we ask however many household members there are, and they say they're all fine. What level of information, one, can be accepted for GDPR, but also how we cover ourselves in terms of reasonable and best endeavours?
Yeah, difficult one, because I think there's an element here of, because we've talked about this around profiling of, you kind of know who your residents are, and you could start tracking, and it becomes a bit invasive. If you knock on the door, who answers? Have they got legal capacity, if you like. What happens if a teenager answers the door? Do you not talk to them? Do you talk to them? My gut feel is it would be on reasonableness, is that, you know, we for example have put a request or an offer on the notice board in the building. We've written to we put a note through everybody's door. We've put something in our resident engagement meeting. We've knocked on all the doors and spoke to people. To my mind, without testing it in a court, that would be reasonable. Similarly, if someone was to say, I haven't got any issues, but my wife would need to talk to you, but she's at work at the moment, can we arrange a time? I don't see a problem with that referral. It's a familial referral. I don't know, what do you think, Elspeth?
I think, Matt, that's one approach, but I would actually start with what information have you already got within your systems? Because one of the things that we learned from the final report of the GTI in chapter 6, where it was made very clear that RBKC TMO knew that 16 of the 19 disabled people who died, they were already fully aware that they were disabled, and that was from their records from when they took out their leases. They were also aware of a further two because they'd applied for accessible parking spaces, which is a pretty good indication. So it's very much looking at the information that you already have, but also we call it network fire safety, making sure that your contractors, if they have concerns, that there is a way that they can raise, because they're often the people who are in and out. So it's a multifaceted approach, along with knocking on doors and all the things that Matt has mentioned.
Thank you.
Let's next question, Richard, if you can bring them in.
Yeah, so we've got a couple of questions here from Hannah in the chat. First one is, what level of information is considered suitable in an SIV, and is it just the door number and assistance needed? And then the second question she asks is, do we envisage that RPs will be expected to physically get residents out of the building in the event that they do not wish to remain in a protected place, assuming that you have a stable policy?
Can we take the second one first?
Yep.
No. You should not be sending people back into a burning building. That to my view is not the job of a responsible person, right? That's the job of the fire service. So that would be my first point there. And I think that this also, sort of diverting the question slightly, applies to these sort of buddy systems and neighbours, etc., that I think we've got to be very careful with. Back to Elspeth's point of writing things down, of actually formalising these requirements, that they are voluntary, they are not mandatory, and we shouldn't be going back in and going back into danger. If we have to get out, we have to get out. That's the point.
We avoid traditionally ever since we've been doing PEEPs and strategies, we avoid using employees unless we have absolutely no choice, i.e. in a workplace that's controlled, because of the health and safety at work and management of work regulations. And our view is that an employee can only ever be a volunteer. And certainly the legal advice that we've considered, and we regularly test for our training courses, legal opinions, in that the risk from using a neighbour, family member, and family members are not going to abandon their disabled people. So giving them the information and knowledge and equipment to be able to do so is productive. But using volunteers, it's much less risky for the organisation than trying to use employees. And our view is that there's only one place an employee such as the concierge should be, and that's out in the car park, waiting to meet the FRS when they arrive and directing people to the assembly points. Certainly not running around buildings, whether they're a waking watch or whoever they are.
Hannah has her hand up. Did you want to add something to that, Hannah?
Yes,
I do have a slight ulterior motive, and it absolutely isn't for here, but I would really appreciate if anybody has some time following on. I was here very much from the RPEEPs perspective, but we've actually got a building going through Gateway 3 at the moment, and we have LABC insisting that we do just this, and I am virulently challenging their view. So basically, they're refusing to pass a building because they're saying it doesn't meet building regulations because it doesn't have an evacuation list, even though that is not yet a requirement. And they are then saying that there needs to be a management strategy that's put in place, which they are suggesting is the managing agent physically gets people out of that building.
Okay, Hannah, you're chopping out, but I think I got some. Like, would you be able to follow up with us afterwards on that one? Because I think it's quite a detailed question that I'd like to consider. There's a couple of quick questions here. So, what level of competency do the people conducting the risk assessment require? From Helen. The regulations specifically say that you shouldn't need any specialist knowledge to be able to conduct PCFRA. I'm not personally sure if I took somebody off the counter at McDonald's and said, go and do a PCFRA for Mrs. Miggins, that would cut the mustard. So mixing my metaphors there. So I would say at minimum, basic training, and go and speak to someone like Elspeth to help with that. Ultimately, you might not need to be a fire engineer to do this, but you certainly probably need to know a little bit about the subject and the basics. And I would say book onto a training course and make sure people have got a basic level of competency to do this. That's
Matthew's asked, can we hire a consultant to run the process on our behalf?
Shall I jump in on that, Matt?
Yeah.
Well, you can do, but given that you're going to be talking about 24% of your residents being evacuation impaired in any one building, yes, a consultant might be able to help you develop a strategy. I would suggest that certainly our experience would be counterproductive to ask somebody to actually go in and do the PCFRA or the PEEP. Normally, you're considering that people are discussing quite personal details, which Matt has already referred to, that it should be somebody that at least they recognise, either their building safety manager, the name, or their resident engagement manager. Bringing people in externally, certainly our experience would be that it would be unhelpful.
I think designing the process and helping you develop standard forms, approaches, technology, etc. Absolutely, but I think perhaps you could outsource somebody coming in to do the actual home visits, but if you need them. But yeah, just think very carefully about who that is and how they do it.
We have technically run out of time, but if you want to take just one more question, Malcolm says, can a BEEP be as simple as this building has a stay put evacuation strategy?
It could, but I think you would need to explain what that is, because you're already doing that under the Fire Safety England regs in terms of the evacuation strategy. So you've got to explain what that means. And you also would need to, even if it's a confirming a negative, that there are no relevant residents that you're aware of that require an emergency evacuation statement, etc., to turn it into a BEEP, which it conforms with the regulations. Have I got that right, Elspeth?
Yes, although I would suggest for these in-scope buildings that would be highly unlikely to have any building Indeed. That has nobody evacuation impaired. And even in a stay put building, you have to consider what happens if the disabled person's flat is on fire. And I don't think any building manager or responsible person would suggest, well, stay in the flat, stay put. The protocol is you move away. And so at the very least, there has to be a plan for them to be able to at least move away 2 floors, if not. Essentially, they should be able to, and the legal guidance in the government guidance for means of escape for disabled people, there should be an evacuation plan, including disabled people, for them all to evacuate the building, and it should not involve the fire and rescue services to make it work. And that's been in place since 2007.
Brilliant, thank you. At that point, I'm going to pull stumps because we are over time. If anybody's got residual questions, we'll download the chat. If anyone's got particular questions, please contact me or Elspeth. I think we're pretty easy to find. Get yourselves regulator ready. See you again on the 2nd of April. Thank you very much for coming. Apologies for us having to cut short, but we could have had 10 hours on this. And hopefully we'll see you on the next one. And we will be sending out to everybody a copy of the presentation and a copy of the slides and all that sort of stuff. So we'll see you again soon. And please do send us a message if you need us for anything. Thank you.